What's up, everybody? We are back discussing Karen Reed today, but in a little bit of a different way as the court goes to civil. I should say the case. The case goes to civil court, not just criminal court at this point. How does it affect the criminal case? Why did they pick these causes of action? What will insurance cover? What will it not cover? We're going to talk about all that. We're going to talk about as much as we possibly can about the civil lawsuit today that was filed against Karen Reed for the wrongful death of John O'Keefe by John O'Keefe's family members. So let's get into it. All right, we're going to bring up the lawsuit here and we're going to read it in its entirety. I assume a lot of people are going to have a lot of different questions. Okay. And when we talk about a little civil lawsuit, there are all sorts of different aspects of it that can affect a criminal case, can be affected by a criminal case. It can go vice versa, go both ways on it. On the civil can affect the criminal can affect the civil. So we're going to try to cover as much of that as we possibly can. We're going to cover how the facts that are pled in the complaint, how specific they have to be, but not as specific as they have to be. You don't have to say every little detail, but if there are things that came out differently in the criminal case, how that's going to be dealt with in civil court. We'll talk about why certain causes of action are picked, because certain causes of action trigger insurance policies and other causes of action don't. But the causes of action you're choosing and the plaintiffs are signing off on as the facts in this complaint could be used against them in a future criminal trial. So if you say it's an accident now, but you say it was on purpose later, how's that going to look in front of a jury? So keep all that in mind. I see people saying, will Bev be over this? I've seen this question a lot because she's a civil judge, I guess, but doing the criminal case. I have never had a situation where the same judge handles a criminal and a civil case. But I don't want to say no. I don't practice in Massachusetts. I have had a case or two there over my career, but not specifically adept at how that would possibly work and how they assign their judges to the cases. So I'm not positive about that. That's something we'll have to just kind of wait and see. That would be wild to me. I would hope not. I would hope that's not how it works, but we'll wait and see. All right, let's jump into this complaint here. So, filed on August 26th, which is literally today. So hot off the presses. Parties and jurisdiction. So the way every civil lawsuit starts is who are the parties? What's happening? People are saying it's in a different county. Okay. Plaintiff. So here are the plaintiffs. Paul O'Keefe, surviving brother of John O'Keefe, duly appointed PR of the estate of John O'Keefe, who died on January 22nd, 2022. At all times, relevant material here too. The decedent resided in Canton. Okay. So this is just kind of making sure we know who the players are, if this is the proper jurisdiction, if this is the proper venue. That's what this is for, but it's important because we know at least Paul O'Keefe, and I believe Kaylee as well, even though we didn't get to watch it, testified at the criminal trial. So them being the plaintiffs, you have to sign off. And these facts that your lawyer write, you have to ratify. And if you're asked about, this can literally be used to impeach you on the stand if you say something and they're saying, doesn't it say in this complaint X, Y, and Z? And they're like, no, I didn't write that. My lawyer wrote that. I don't believe that. And then it screws up this complaint as well. And that may be important. We'll talk about the timing of all of this. Number two, plaintiff John O'Keefe II, who is the surviving father of John O'Keefe. Plaintiff Margaret O'Keefe, the surviving mother of John O'Keefe. Plaintiff Kaylee Furbish, the surviving niece of John O'Keefe, who we know he was the guardian of. Okay, so those are the plaintiffs. Now, why not his nephew? We'll talk about why, maybe, potentially. Maybe the nephew didn't want to do it. We'll talk about all that, but there could be some legal reasons for it. But those are the four plaintiffs. Now we get the defendant. CNC Hospitality, doing business as CF McCarthy's. We know that. Okay. The defendant, Waterfall Bar and Grill. We've heard of them. And then lastly, of course, Karen Reed. So three parties we're very familiar with. We know all about the parts that they allegedly played in the criminal case. We've seen videos. We've seen bar tabs. We've heard from employees from these places who were friendly to the state and the victims. Will that change? That's the question, right? Because now Some people that were maybe cooperative with the victims in the state. Will that change now that they're being sued? I don't know. Why did they choose now to file this lawsuit? Was it strategic? Did they want to wait till now? Were they saving this punch for the PR battle after the first trial? Or did they really not want to file it and was their hand forced? We're going to talk about that. I mean, I love breaking down civil lawsuits because there's so much strategy. It's not just the state attorney. It's not just the government. These are private lawyers making these strategic legal decisions, how and when to make these claims. So let's get to the facts. As they are going to plead them, these are allegations. As far as the plaintiffs are concerned, this is what they believe happened. And if there are any motions to dismiss based on the four corners of the complaint, these will be assumed to be true, viewed in the facts most favorable to the plaintiffs. So just because a lawsuit doesn't get dismissed in civil court doesn't mean everything that's alleged in the complaint is true. It just means they're taken as true at this point for making these claims. Brianna said, do you ever take wrongful death cases? This is a large amount of my cases are wrongful death cases. This is one of the types of cases we focus on. So how and why they did it the way that they did is, to me, always interesting just to look and see how lawyers are doing things. I always learn. I like to learn new ways and new things and try to figure out why and how the strategy behind the decisions they make are. So let's look at but we have to keep everything in mind, right? Like we have to know as civil lawyers filing this wrongful death claim that there's a criminal case going on at the same time. Okay? I'm going to read the facts and then we'll talk about a lot of the crossover. Plaintiffs repeat, reallege, and incorporate by reference as if set forth hereto in their entirety all paragraphs of the complaint. The decedent, JJ, was the middle of three children in a tight-knit family. JJ was a third-generation Boston police officer. After his tragic death, JJ's sister, Kristen, and brother-in-law, Steve, JJ, took custody, guardianship of his niece, Kaylee, and nephew, Patrick, who were 6 and 3, respectively. Over the next 8 years until his tragic passing, JJ raised and supported his niece and nephew. And that's important. You'll see why and hear why as we discuss why they pick certain people to be plaintiffs, who you can pick, who you can't pick. After the tragic death of JJ, Margaret took guardianship custody of her grandchildren, Kaylee and Patrick. At all times relevant, if you'll notice when I read fast sometimes, at all times relevant here too is what we put in our complaints. So that's just like in my head. So I read that because that's how I think they're going to wind up some of these paragraphs. So I will probably stutter over that a couple times, just reading how they say it. At all relevant times on or before January 29th, 2022, JJ and defendant Reed were dating and in a relationship. In the months, weeks, and days leading up to January 29th, 2022, JJ and the defendant Reed's relationship was deteriorating. During such time, defendant Reed picked fights, experienced jealousy, and had delusions of unfaithfulness. On or about January 28, 2022, defendant Reed knew that her relationship with JJ had run its course. On January 28th at 8:51 p.m., plaintiff arrived at C.F. McCarthy's. C.F. McCarthy's was licensed to distribute, sell, or serve alcohol. Why is that important? Well, only certain establishments can you sue for dram shop cases. This is going to be a dram shop case. If you guys know what dram shop cases are, let me know in the chat. Most people know that buzzword. And a lot of these laws were put in place to try and protect people from themselves, basically at certain establishments. And generally speaking, a dram shop case is you cannot serve alcohol to a minor, or you cannot, or I should say, or you cannot serve alcohol to somebody you know or should have known is already intoxicated when you're serving them alcohol, aka over serving. But in different jurisdictions, you can sue different places for that. Some places you can sue homeowners or private events and things like that. Other places, it has to be an establishment that serves alcohol and actually be a commercial environment like C.F. McCarthy's. That's why you plead certain facts like this. That may not seem like something that's important if we're just reading it, but it is very important to hook certain defendants with certain causes of action. On January 29, 2022, on or about 8:58, C.F. McCarthy's served Reed an alcoholic beverage. Reed consumed said drink. On January 28, 2022, C.F. McCarthy, through its agents, servers, or employees, served alcoholic beverages to defendant Reed on or about so we have 8:58 as number 1, 9:13 as 2, 9:20 as 3, 9:33 as 4, 9:57 as 5, 10:22 as 6, 10:29 as 7. Reed consumed such drinks. That's 7 drinks. That's a lot. We watched the video together. As the prosecutor and the officer were on the stand, it seemed like when they were going, yeah, okay, that's drink 1, that's drink 2, that's drink 3. So there's a lot of drinks, but you couldn't really tell. Are those shots? Are those refills? Are they water? What are they? So they're going to have to prove this up. Okay. They're going to have to prove that they were actually 7 drinks. But here's one of the issues. From 8:58 to 9:57, it's not just you serve them enough drinks to get them drunk. Okay. But did you know or should have known they were drunk? How do you prove that? You can prove it with blood alcohol level or breath test. How many bars do that? Not many. Okay. Or testimony from other people or video evidence. Are they falling all over themselves? Are they throwing up at the table and you're continuing to serve them? Is it very obvious they're intoxicated? So what do they know about, or what do we know, I should say, from watching the trial about the people that saw her that night? Nobody said she seemed intoxicated. None of her friends that testified and were drinking with her, hanging out, eating with her said, maybe you shouldn't drive. Nobody visibly said that they saw and they felt like she was intoxicated. So how should the bartender know or should have known? Most jurisdictions don't have a limit. Like if you serve 7, you should know that they're drunk. If you serve 5, you can use that as part of the argument and discussion to the jury, but it doesn't automatically mean you knew or should have known that that person was intoxicated. They'll need to do more than just play that video of her holding all these drinks or refills or whatever it is. We're going to need more than that, in my opinion, to win, not to go forward. It's not going to get dismissed based off this, but to me, this sounds like a lot better evidence than it is. CF McCarthy's, through its agents, servants, and employees, served defendant Reed 7 drinks between 8:58 and 10:29. I thought 9:57 was the last one. Okay, it's 10:29, so an hour and a half on January 28, 2022. During all relevant times at or before 10:29 on January 28, defendant Reed showed signs of intoxication while at CF McCarthy's. Why is that line in there, folks? Just what we talked about. They have to prove, the plaintiffs, the O'Keefes, have to prove she showed signs of intoxication. Not just 7 drinks, must have been intoxicated, therefore slam dunk, dram shop case. And this is the type of stuff that can get you thrown out on a motion to dismiss. If you don't even plead and say she showed signs of intoxication, the judge may throw it out and say, I'm looking at the complaint and I'm taking all these facts as if they're true, but you're missing an essential element. Did she show signs of intoxication? If you admit she didn't, you lose. You can't go forward. So that's why you have to plead this stuff. And then obviously throughout the case and throughout discovery in the civil case, you're going to have somebody prove and say with evidence and testimony or video evidence that she showed signs of intoxication. But if you don't even say it in the complaint, that's what can get your case dismissed, because you have to at least plead all the facts necessary to prove the elements of the cause of action you are seeking to prove. We're going to hear more of this when we dig into the actual causes of action. But I just want to point out why some of these facts are important, where they otherwise might not seem that way. All right, January 28, 10:40, they leave CF McCarthy's. At or about 10:40, defendant Reed was allowed to carry her alcoholic drink out of CF McCarthy's. That's not a good look, but it also doesn't prove dram shop, but not a good look. You shouldn't do that. But that alone is not enough to connect the bar for dram shop. If it's a minor and you're serving and they go hit somebody, it's pretty slam dunkish. If the person's puking at the bar, falling over, you can continue to serve them, pretty slam dunkish, as it should be. It is your responsibility as an establishment to hire and train people that are not going to do this. We've handled a lot of dram shop cases. I would not say that's our specialty as much as, wrongful death and trucking accidents, car accident type cases that end in death. But dram shop cases are difficult to find one that hits all the elements, but when it hits all the elements, they're good cases. And you're going to hear what some of those elements are as we go. Okay. Then they enter the waterfall at 10:54. At all relevant times, Waterfall was licensed to distribute, sell, or serve alcohol. We know why that's there. Defendant Reed walked into Waterfall carrying a drink from CF McCarthy's. Okay. How were they supposed to know what was in it? I mean, hindsight, I get it, but it's worse to let her walk out with it than walk in somewhere, in my opinion. At all relevant times on January 29, 2022, Waterfall At the waterfall, defendant Reed showed signs of intoxication. Again, why is this so important? Why is this so important? Well, especially at the waterfall, because at CF McCarthy's, they have the evidence that she was served 7 drinks. They have the evidence at this point. We're going to assume it's true. It's in the allegations in the complaint. Okay. So she had those 7 drinks, but at 10:40, she shows up at the waterfall. The waterfall doesn't know that she had those prior 7 drinks. Unless somebody told the bartender or they were on notice somehow, or somebody sent the video ahead of time, which, obviously didn't happen. They don't know. So those 7 drinks don't really come into the waterfall bartender's mind. But what does come into her mind? How does she look? Does she look intoxicated? Does she seem intoxicated? Does she sound intoxicated? And that's really your only answer at the waterfall. The answer is no, you're probably going to lose. The answer is yes, and she looked and sounded incredibly intoxicated. Doesn't matter where she had those prior drinks. Could have been at her house. Could have been at CF McCarthy's. Doesn't matter. You can't serve her if she's obviously visibly intoxicated. So they have to say she was showing signs, and they have to prove it to win. Between 10:54 and 11:54, defendant Waterfall served Reed 1 shot and 1 mixed alcohol drink. Reed consumed such drinks. So this is important as well, because you have to actually serve them alcohol while knowing that they are intoxicated. So if they didn't serve them any drinks and Reed comes in and they know she's drunk, it's not their fault if she goes and drives, because they didn't serve her any alcohol. So they had to serve her drinks, which they're alleging 1 shot, 1 mixed drink. On January 29th at 12:10 a.m., she left the waterfall. 12:11, John O'Keefe left the waterfall. They say JJ. I know that's what he's called. In my head, it's JO. At all relevant times on January 29th, between 12:11 and 12:36, defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. And now you start to hear them pointing the finger at Karen Reed, not just the bars. Okay, because there's going to be multiple causes of action here we're going to go to. Keita G. Plot twist. The O'Keefes are trying to help Karen by filing this now because WTF. I don't think they're trying to help her. But let's go ahead and talk about this now. So, and Nick T said no 2-year statute of limitations in Massachusetts, I assume. I believe it is 3 years in Massachusetts for intentional torts and negligent torts, like are claimed in the causes of action here, including dram shop and negligent and intentional infliction of emotional distress. Okay. So if the statute of limitations is 3 years, and this happened on January 22nd of 2022, we are about to be in January of 2025, which would be 3 years. That's right around when the trial starts. It will not be concluded by then. So they have to file this now in order to protect their rights and not lose the case because of the statute of limitations, where is potentially malpractice on the part of the plaintiff's lawyer if they let this go through and don't file within the 3 years. So my opinion, as a plaintiff's lawyer who's handled these cases with accompanying criminal cases, the best way you do it is to wait until the criminal case concludes, you get a conviction, and then a lot of this is per se. The DUI could be per se, the wrongful death could be per se, res judicata, higher standard of proof in the criminal case. Jury's already found her guilty that she DUI and caused the death. That makes the civil case a lot easier. But you do not have to wait for the criminal case to conclude. And that's a bigger question than a lot of people asked. How is this possible? The jury didn't find her guilty. Totally separate case. Even if they never brought a criminal case against Karen Reed, never brought it. Cops didn't think it was her fault. Cops didn't think she was drunk. Whatever. Cops didn't think it was an accident. That does not bar a civil lawsuit exactly like this. Makes it a lot easier when there's a criminal case, of course. It does a lot of your discovery for you. Not sure they're going to want to use it, but as a plaintiff's lawyer, and it can make your job much easier, or maybe in certain circumstances make it harder like this. So I absolutely do not think that they wanted to file this lawsuit until after the criminal case, which means I think it was more of their hand was forced here. I don't think this was a strategic move that they felt was a good time to do it right now. That's my opinion. I don't know that that's true. I don't know the strategic decisions and conversations they've obviously been having, But if this was so great and they wanted to file it, they could have filed it right after it all happened. It could have been even before the criminal case, potentially. But they didn't. So that's my take on the timing. All right, let's keep reading the facts here. At all relevant times on January 29, 2022, defendant Reed drove JJ to the residence of 34 Fairview in Canton. At least they got the address right. Defendant Reed and JJ had been in an argument the night of January 28th into the early morning of January 29th. So what is the argument they're going to talk about here, you think? Is it going to be Karen Reed's voicemails, the text messages? Is it going to be something that the kids testified to? Because a lot of the people are testifying they were fine while they were at the bar immediately preceding his death. After JJ got out of the defendant's vehicle in front of 34 Fairview, Reed drove her SUV and hit JJ. Okay? So far, we can't really tell. Is it on purpose? Is it on accident? Why did she hit him with her car, as they're alleging? That's important. Is it intentional? Is it on accident? At all relevant times on January 29, 2022, defendant Reed drove her SUV in a state of intoxication. So there's the drunk driving element. That's important for the dram shop. That's important for the wrongful death. As a result of Reed's SUV hitting JJ on January 29, 2022, JJ was knocked down onto the ground in front of 34 Fairview, suffered serious injuries, and died. That is the damages element. So in any negligence case, you have duty, what you're supposed to do, a breach of duty, you didn't do it. Causation, meaning you were the cause of the damages. Damages are an element. Sometimes they seem obvious or given, but you still have to prove them. And these are the damages they will easily be able to prove in this case, because we know that he did suffer serious injuries and die. But they have to, and duty is also an easy one to prove. You have a duty not to drive drunk and not to hit people with your car. But can they prove breach of duty and causation? Those are the two biggest questions in this case and in most cases. After hitting JJ with her SUV, defendant Reed fled the scene and returned to JJ's residence at 1 Meadows Avenue. Sounds a little bit like count 3 of the indictment. At all relevant times, defendant Reed knew, I should say, it's a good point, Peter. Why don't we point this out too? These paragraphs all sound a lot like count 2 and the lesser includeds in the criminal indictment. So we see counts 2 and 3 in here, even if it's just lesser includeds. Will we see count 1? Will we see a depraved heart that she was angry and did this on purpose? At all relevant times, defendant Reed knew that it was snowing, knew there was an impending blizzard, and knew or should have known that leaving JJ outside in the blizzard would likely result in serious injury or death. At all relevant times, when defendant Reed drove her SUV and hit JJ, defendant Reed, here is what she did wrong, okay? She failed to use any care to avoid creating an unreasonable risk of harm to the public and JJ. She voluntarily took an obvious risk under the circumstances, knew or should have known that death or serious injury was reasonably predictable. So this sounds intentional, voluntarily did this, but it's really more legally defined as recklessness. Reckless disregard. Persisted in a clearly negligent course of conduct over a noticeable period of time, was impatient with reasonable precautions, was, again, feels intentional, but deliberately inattentive, not paying attention to the predictable hazards of her actions, was deliberately inattentive when there was a risk of great and immediate danger. That's all pretty much gross negligence, recklessness, and negligence pled so far. At all relevant times when defendant Reed drove her SUV and hit JJ, defendant Reed was reckless when I was just looking at this, how they introduced this one. Kind of weird to do this twice like this, but she intended the reckless conduct that resulted in JJ's injury or death. So that is as intentional as it gets. She intended it, but she intended the reckless conduct. To me, it sounds a little bit like they're towing the line here or straddling intentional versus negligent actions. Her conduct made it highly likely that someone, namely JJ, would suffer serious injuries or die. That's recklessness, okay? Or gross negligence. She knew or had reason to know of the risk of grave injury or death to JJ, or said risk would have been obvious to a reasonable person. She intentionally or unreasonably disregarded the risk. JJ's injuries or death resulted from defendant Reed's decision to engage in the conduct referenced above. That's what you call causation. Her actions caused his death. And her breach of duty was, your duty is to not drive drunk or not drive recklessly. She drove drunk and drove recklessly is what they're alleging. So that's how they're getting through step by step the elements. Let me answer a couple questions here. Which do you think will go faster, civil or criminal? Definitely criminal. Civil will go much slower. In fact, if they wanted to, now that they've filed the lawsuit here, they've gotten in just in time under the statute of limitations. They don't really have to do much, if any, discovery before the criminal trial is over. They can tell the court and civil court judge, we're just going to wait now, stay this case till the criminal case over. They don't have to do that, but they could. It could move very slowly. There are certain things that could make it move quickly, which we'll talk about a little later in the video. Karen should countersue and name the third-party culprits and the incompetent police department as parties. The depositions should be fun. Yes, there are legal things that she can do and maneuver around with other people she may believe are the actual liable parties in the civil case. I'm probably going to have to do a part 2 for that because there's just so much. We're already almost 30 minutes in. I'm not even halfway through this document. So are they suing the bars because they served KR or JO? KR. Because they served Karen Reed. This is the allegation. When I say things in a civil world, okay, there's no presumption of innocence. It's almost the opposite. You presume the facts to be true in the complaint. But then if they don't prove them at trial, obviously they lose. But that's how we read this, as if it's true, because that's how we have to determine if they're going to be able to continue to move forward. So they're alleging that these bars knew or should have known Karen Reed was intoxicated and served her anyway. John, I've heard of this claim before, but it seems difficult to prove. Percentage of success, Peter. I think this was planned to be filed at some point throughout this mess, probably after they were hoping to get a conviction. Because guess what? So far, we've only heard negligent acts. So if you get a conviction on count 2, that's pretty important for these civil claims. Pretty important. That manslaughter, even involuntary manslaughter, would be huge for this civil suit. Percentage of success, let's wait. You have heard this before, John. You want to know where you've heard some of these causes of action that are coming with the negligent infliction of emotional distress type things? Take Care of Maya and Gabby Petito. The name slipped my mind. And Gabby Petito, both here in Florida. Azam, Peter, can KR counter this suit before the criminal case concludes? Yes, but I don't think she will. My guess is she might have to, depending on the time limits and when your counterclaims and cross claims and everything have to be filed. But there's also ways she can just call them a Fabre defendant, a defendant that's not here, and standing in their shoes and put different people there. Let's talk about this on another video. We'll focus on her defenses and kind of what she can do to bring other people in potentially. Let's focus on the complaint for this video. On January 29th at approximately 4:30 a.m., defendant Reed knew that she hit John O'Keefe with her SUV. That's important. Listen to where they're going here. Nevertheless, she woke up JJ's 14-year-old niece, Kaylee, and talked about JJ's death, talked about hitting JJ with her SUV, and otherwise involved Kaylee in her frantic calls about JJ's death. And now you're starting to see why Kaylee is listed as a plaintiff and not Patrick. Because they're saying Kaylee was involved in this mess and Karen intentionally went and did this to her and it caused her emotional distress. So when we read Kaylee's cause of action, where she is the plaintiff, remember these paragraphs. At all relevant times, on or about January 29, 2022, defendant Reed knew that Kaylee was a vulnerable minor who already lost her parents tragically and depended on her custodial uncle, JJ, who became her surrogate parent. At or about 5:07 a.m. on January 29th, the defendant Reed left One Meadows Ave. Okay, so those are the important paragraphs when it comes to Kaylee's cause of action. We're going to read in a little bit. Between 5:18 and 5:35, defendant Reed knew JJ was seriously injured, buried in the snow and laying on the ground in front of 34 Fairview, where defendant Reed left JJ to die hours earlier. On January 29, 2022, defendant Reed admitted repeatedly that she hit JJ. Okay. Of course, they are going to write. This is their time to shine. Nobody's going to argue with you. You get to write these facts down on a piece of paper as if they're true. That's how you should write them. That's how every plaintiff's lawyer writes their facts. And so, of course, they're going to say she admitted doing this multiple times. And we know the arguments that are coming. Did I hit him? I hit him. Maybe I hit him. I think I hit him. We'll talk about that in, kind of part 2 when we talk more about the defenses. I shouldn't presume. If you guys want to, let me know by putting in the comment that you want part 2 on the defenses and hit the like button if you guys haven't already. At or about 6:03 a.m. on January 29, 2022, defendant Reed arrived at 34 Fairview, Canton, and immediately observed JJ lying on the ground, buried in snow where she had left him earlier to die. JJ suffered trauma injuries before becoming hypothermic. Again, I'll start trying to skip this, but they put it in front of everyone. You have to say time and place, when and where and how stuff happened. At 7:50, JJ was pronounced dead at the hospital. After 7:50, Reed went to the grieving house of JJ, feigned comfort to JJ's family, and used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and or destroy relevant evidence. Why is this important? Why are they putting this in here? Because there are also negligent / intentional infliction of emotional distress claims to John O'Keefe's family by Karen Reed. And we'll talk about how you get there and the kind of legal gymnastics sometimes you have to perform to get to these NEID and IIED, which is the infliction of emotional distress claims. On January 29th, defendant Reed's blood was drawn, reading 93 milligrams mg per DL. A serum conversion and retrograde extrapolation was done of the results of the defendant Reed's blood, with the results showing her BAC would have been between 13 and 29% around the time she drove the SUV and hit JJ. So while the defense didn't do a ton of extrapolation to fight with this stuff and say, no, it wouldn't have been, or she didn't drink these drinks, in a civil case, I would think there's going to be a ton of that Karen Reed's team does. Because they're going to say things like, she didn't drink all those drinks, or that was water, and it was actually 3 drinks. And if you do the extrapolation with 3 drinks, it comes back to 0.04, which is below the legal limit. You'll see kind of arguments like that. More on part 2. It exceeds all legal limits in Massachusetts, obviously. It's 0.08 is the legal limit. The defendant Reed drove her SUV while under the influence of alcohol and hit JJ with her SUV. As a direct and or proximate cause, this is causation of Reed's drunk driving. He sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. So this is difficult to discuss, and I understand that, but I do want you guys to understand how, why it's explained like this and how this can affect damages for a second, okay? And this, I don't want this to seem insensitive, okay? This is important in the law. There's case law and statutes that deal with this when you can claim certain damages. If somebody passes immediately after an act, maybe it's a firearm, maybe it's a car, and all the evidence is they passed immediately, you can't claim certain damages like pain and suffering or mental anguish for the deceased. It's immediate. But if you can prove that they did live, even for a short period of time, and they suffered immeasurable pain and suffering, then you can claim that. You can claim the pain, the suffering, the mental anguish, knowing that they're laying there and there's nothing they can do. And that's sometimes the worst pain and suffering and mental anguish you can imagine. And sometimes when we have that in cases and we prove that, that's harder to describe than anything, because somebody trapped there knowing the worst is coming. Can you think of anything worse? And juries understand that. Now, there's a but on that. If you can prove that they still lived, but they were incapacitated to a level where they couldn't feel pain or couldn't understand what was going on or happening to them, then those claims can go away. So there's still some legal arguments that are going to be made on both sides of that. Notwithstanding her Fifth Amendment right not to speak, defendant Reed chose to speak publicly. So maybe we're going to get some of these interviews. People have told me about them. I still have not watched any of her public interviews. She knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. Will we get any causes of action on that? She publicly communicated this false narrative, thereby frustrating justice for John O'Keefe. Such a false narrative caused the plaintiff aggravated emotional distress. The plaintiffs listed above bring this complaint seeking full and complete justice for John O'Keefe. So here's what I'll say. This right here is why this can be shown to these plaintiffs if they testify at the criminal trial, and they are basically ratifying this and signing off on these facts in this complaint. So those are the facts. And by the way, it's always interesting when lawyers hold, claiming you're not guilty, especially after a mistrial, right? A lot of juries think you're not guilty against them. So how's that going to be worked in? Paula Z said, I get the charges, but aren't there text messages from John asking her to pick him up? If so, a police officer wouldn't allow her to drive drunk, right? They can argue that, but it's not the end all be all. Like that, those are going to be arguments, right? Factual arguments you make to a jury to make the final decision. John, could Karen sue the bars too? Maybe for another video. Yeah, I think we can talk about this more for the other video, but it's tough to find ways that they'd be able to help her in this situation. All right, let's get to count one here. The estate of John O'Keefe versus C.F. McCarthy's for wrongful death. Okay, so it's the first count one against the bar by O'Keefe's estate. The estate repeats the facts above. Here's what they say they did. And this is where you see them hit the causes of action: duty, breach, causation, damages. And with Dram Shop, you'll see some extra stuff in there. And negligent infliction of emotional stress, you'll see some extra elements in there. So C.F. McCarthy's negligently served alcohol to an intoxicated person. Has to be to an intoxicated person. Can't just be to anyone. It could be a minor, but that's not what we have here. Defendant knew or should have known that defendant Reed was intoxicated at relevant times of service on January 28, 2022. They have to prove this. Here's another difference between the civil and criminal case, because she can go win in criminal court and be not guilty, and they can still continue with the civil lawsuit, and she may lose the civil lawsuit because there are different burdens of proof. In a criminal case, it is beyond reasonable doubt. We always say highest burden in the land. You got to be sure, you got to be positive that this is the person. In civil cases, it's mostly who's more right than wrong, preponderance of the evidence, 50.1%, not even all the way to 51%. It's just like you have these two stories. It's kind of like what the criminal case felt like. You have these two stories. Who's more likely right than wrong? It's just, boop. That's all you need for civil cases. For criminal, it needs to be like this. For civil cases, it's more like, boop. So very different causes of action. And there have been cases where the defendant won in criminal court and lost in civil court. Never vice versa. Defendant C.F. McCarthy's violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including but not limited to. So here's where they screwed up, according to the plaintiffs. In its decision not to hire competent employees, staff, bartenders, its decision not to provide adequate personnel to work at C.F. McCarthy's, not to provide adequate safety training. Like, here's what to look for. If somebody's intoxicated, you stop, you cut them off. I don't care how mad they get. Oof. Imagine cutting off some of the people in that bar as just like a normal person bartender, and you got all these cops and ATF agents and big dudes that have been drinking all night, and they got all their buddies there. Like, that's tough, but you got to do it, or else this could be coming. Its decision to violate its safety training, and these are all, either you didn't do the safety training or you violated it. Either you didn't hire good employees or you didn't train them. You can plead in the alternative all the time. Its choice to retain unfit employees, to keep them, not just to hire them, but to keep them. Its choice not to supervise adequately its employees. So it's like if the bartenders and servers are screwing up, you should have a manager there making sure this stuff is done right and according to your safety protocols. The defendant, C.F. McCarthy's, acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. It acted with gross negligence. Let's take a second and talk about why you might want to plead things like gross negligence. Or I should say, intentional torts. Many intentional torts and gross negligence cases open up the opportunity to get punitive damages, which are damages to punish. Compensatory damages are damages to make whole. Medical bills, lost wages, pain and suffering, mental anguish. Punitive damages are like, we want to teach a lesson to you and all the other bars out there that if you do this, you're going to get punished. If you remember back to Maya, punitive damages were found against Johns Hopkins and compensatory damages as well. So you can't just get punitive damages because you want them or because you ask for them or because it's a negligence case. Only certain circumstances, certain causes of action, there are statutory allowances for punitive damages. And then most of the time in gross negligence and intentional torts, you get the opportunity to get punitive damages. So that's why it's always good if you're a plaintiff's lawyer to be able to plead and prove up these types of causes of action. The defendant acted with willful, wanton, and reckless disregard for the safety of others when it served an intoxicated defendant Reed. So again, this is the language to prove gross negligence. Defendant C.F. McCarthy's deliberately ignored the appreciable risk and or voluntarily incurred the obvious risk of serving defendant Reed when she was already intoxicated. McCarthy's persisted in serving Reed alcohol well after it knew defendant was visibly intoxicated. Again, how are they going to prove this? I'm interested to see how they prove this. Defendant C.F. McCarthy continued to serve Reed alcohol at relevant times when Reed was already intoxicated. As a direct and proximate result of defendant C.F. McCarthy's negligence, gross negligence, and or willful wanton disregard for safety, JJ sustained serious bodily injuries, serious injuries, I should say, of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial bills, and died. As a direct and proximate result, C.F. McCarthy's negligence, JJ's next of kin suffered as well. JJ's next of kin are entitled to JJ's lost value resulting in wrongful death. Such damages include, but are not limited to, reasonable expected society, companionship, comfort, guidance, counsel, net income, services, assistance, protection, care, and advice of each next of kin. Each jurisdiction has different things and people that you can sue for, and that can be considered next of kin and part of the estate, but there are additional damages they're claiming there. So what are they asking for? Costs, compensatory and punitive damages, lost value of next of kin, and other relief the court deems appropriate. Okay? Punitive damages. That's the big one there. Can you cover the Turtle Boy KR interview? I have not seen it. I have not seen it. If there's a video, send it to me, and I'll see if there's some stuff in there to break down. All right, count 2, Waterfall Bar and Grill. Basically the same. Dram shop laws. They didn't hire. They didn't provide adequate personnel. They didn't train. They violated training. They retained unfit employees. They chose not to supervise adequately. They showed an indifference. They acted in gross negligence. They were willful, wanton, and reckless. They deliberately ignored appreciable risk, continued to serve her. It was a direct and proximate cause, serious bodily injuries to John O'Keefe and his next of kin. They want punitive damages, compensatory damages, and any other such relief the court deems adequate. Basically mirrored dram shop causes of action. All right, count 3. Here we go. State of John O'Keefe. Who's the defendant here? Karen Reed. Wrongful death. So just FYI, wrongful death can be intentional or negligent. Plaintiff realleges the paragraphs above. On the date of the crash, at all times, at all relevant times, defendant Reed owed JJ and the public a duty not to drink and drive, to drive her vehicle safely and or with due care. That's the duty. Okay? That's her duty. Everybody's duty. On that date, she owed JJ and the public a duty to pay attention to the roadway. She breached her duty, right? This is element number 2, breach of duty. She breached her duty by driving drunk, driving in an unsafe manner, and without due care. This looks like any DUI complaint. Obviously, if it ended in death, it becomes a wrongful death. If there was no drinking element, it would just be driving unsafe or without due care. As a direct and proximate cause of Reed's negligence, gross negligence, willful, wanton, and reckless disregard for safety, JJ sustained serious injuries of mind and body, conscious pain and suffering, fear of impending death, lost earnings, and as a direct and proximate cause of her negligence, also the next of kin suffered. What do you not see? Intentional conduct. So I do not see in this cause of action about what Karen Reed did to see any element of intentional crimes or torts. Why is that good? Why is that bad? And for who, I guess, right? Everything's good and bad for somebody. It is good for Karen Reed, because if I'm her lawyers, this has been filed now. I am going to use this. I am going to read these paragraphs to Paul O'Keefe. Maybe you want to do it with Kaylee, maybe not, but definitely to Paul O'Keefe, and say, maybe before I even read him this, you agree that Karen Reed didn't do any of this on purpose, right? You agree. You think that she drove drunk and hit your brother and left him there, but you agree it was an accident. It was negligence. It was reckless, but you don't think it was intentional. And if they say that they do, then you read them, the paragraphs in these causes of action, the facts in this complaint. You also now have, of course, bias, right? I don't think it's that big of a deal. If I was a juror, I would expect the family to sue Karen Reed if they think she did it. But I am a lawyer, a PI lawyer, so I expect people to do things like this. If you believe somebody killed your brother, and if they have money or insurance that can help take care of Kaylee and help you deal with the issues you're going through, help you maybe keep a roof over their head, punish people for their serious wrongdoing. If I believe that's true, I expect lawsuits like this to be filed. I know people won't necessarily always agree with me on that, but I don't think it's that big of a bias tool, but it is there. The bigger tool for me is none of you guys even think this was intentional. Okay, sorry. So why is it good for the plaintiff? Why is it good for the O'Keefes that there's no intentional conduct pled here? Insurance. Most insurances will deny claims for intentional torts or criminal conduct. It'll be in their policy that they're not going to pay. But for negligent claims, even grossly negligent claims, many times insurance will cover. And what does cover mean? A, it could obviously mean paying money, paying for the settlement up to a cap or insurance limit. But number two, it could also mean paying for a defense, cost of defense. I'll have to look at if there are statutory caps for wrongful death or punitive damages or compensatory damages in Massachusetts. I haven't done any of that research yet. But if there are caps, or let's say her insurance limit, her car insurance limit is, $100,000, they may just pay it, even if she's got a strong case. And they may pay it over her objection. Or they may say, if you don't let us pay this, this is how it works in the background, right? Insurance companies control their money. Even though these lawyers represent you, they actually represent the insurance company in their best interest. I've done videos of this. I have broken down at length what it actually means when, insurance defense lawyers represent you. But sometimes they'll let you say, absolutely not, don't pay $1 because you could affect my criminal case. I'll sue you if you do this. But if you do something like that, you eat the liability. And you say, I'll pay if I lose, and you let the insurance company off the hook. Sometimes they'll allow something like that. But if this case settles like this, people in the news are going to be like, oh, Karen Reed paid. Karen Reed paid him off. But that could be a business decision made by an insurance company because the damages could be astronomical in a wrongful death case. And many times they just tender policies if they're 100, 250, 500, even $1 million sometimes. They'll just tender it because they got to pay lawyers and experts and fees and costs all throughout the case. And then if they lose, they still have to pay the verdict. So sometimes it's just a business decision made by an insurance company. So they pay for lawyers and experts and things like that, but reasonably and usually of their choosing, meaning the insurance companies. We broke this down a little bit in the Amber Heard case, but there are times where insurance companies will let you pick your lawyer. What are those times? Well, if you're willing to pay either the full amount for the lawyer, sure, they'll let you pick if they don't have to pay and you sign off on that. Or if they have in-house counsel or somebody they have an agreement with and they pay them $250 an hour and your lawyers charge $500 an hour, sometimes they'll pay $250 and let you pay the rest, whether it's another $250 or $500 or whatever it may be. Same thing with experts. If you want to hire more expensive experts, maybe they'll cover what they were going to cover and you cover the overages. Sometimes they'll work with you that way. Or a possibility in this case, and I've seen this happen before, if there are lawyers already on the case and it will save the insurance company money, instead of paying new lawyers to get up to speed on trials and depositions and witness statements and statements by the defendant, if instead hiring Jackson and Yannetti will actually save the insurance company money in the long run because they're already up to speed on the case, maybe they'll do that, or some combination of the 2 or 3 things that I said. So it's possible Jackson and Yannetti handle the civil side. Probably more likely they bring in their own civil insurance defense attorneys to handle this insurance defense claim. Additionally, with car insurance, sometimes they'll deny claims if it's a DUI, even if it's negligent. Sometimes they'll deny claims for gross negligence as well. It all depends on the verbiage in the insurance policy. Okay. So again, looking for punitive damages on DUI cases. Yeah, especially causing death, you can get punitive damages. All right. So let's get into kind of the next section of complaints. And that's negligent infliction of emotional distress. Actually, before we do, let me hit a couple questions. Sue, Bev was a criminal case when this all started, changed to civil during the case, and just stayed on this one. Yeah, not unusual for judges to rotate between criminal, civil, probate, family law. If they were to win and get a judgment, could it be wiped out in bankruptcy? So I'm not a bankruptcy expert, but yes, there are ways bankruptcy can protect you or cover most of it or part of it. So yes, that is part of it. But I would expect car insurance and her personal assets or finances to be on the line here, not her parents. You can't go after somebody's parents unless they have wrongdoing. They're not a defendant here. And when it comes to the bars, their insurance usually will cover dram shop cases. Not always, but usually will cover it. They usually have higher commercial policies. Some lower level mom and pop establishments don't have any insurance, and they could just go out of business. Then you don't collect, but you're putting them out of business. So there's all sorts of different things. And sometimes cases settle for less than you think if there's no money there. Sometimes they settle more than you think if it's confidential with big insurance policies. When it's confidential, you never really know. You never really know how much money somebody's got, right? That's something I've learned along the way here. Sometimes big establishments and people seem like they got a lot of money or they're show-offs or whatever. Then when it comes down to it, they actually don't, or they're good at hiding it. So all of those things can come into play. Have to go, but I have to say that your TELUS coverage was awesome and hilarious. More, please. So I'm actually thinking about live streaming the verdict if I'm able to. My whole family is out tonight at an event. So I am planning on doing a Corey Richins recap of the first day of the preliminary hearing. But if TELUS goes on verdict watch or the verdict comes back, I think they're doing closing arguments now. I may live stream it. If you guys want it, throw it in the chat. Tommy, Peter, how much easier is discovery in civil? Will this be the gift from God for Karen? All the phone records Bev kept out, and can FBI be mentioned? So FBI probably unlikely to be mentioned, but discovery is even slower in civil cases because you don't have a criminal defendant's constitutional right to a speedy and fair trial and all this stuff that you can really throw. The courts care a lot more about the constitutional rights of criminal defendants than they do civil plaintiffs or civil defendants. So it's usually much slower. Objections, waiting 3 months to get a hearing date. It's not usually faster, but having a criminal case will help if the prosecutors turn over the file, which most of the time they won't until the criminal case is closed. So you can get certain aspects of it. You can do public records requests, but you don't necessarily get everything right away. Peter, can the inadmissible evidence in the criminal case be admissible in civil? Sometimes. Not always, but some evidence will be admissible in one and not in the other. So it'll really depend on the piece of evidence. Third-party complaint against the Alberts, why not? I'm going to have to do a part 2 breaking this down. I know this is a question everybody has. Why and why not? What can they do? What can't they do? Because there's a lot to dig into there. But I'm going to end this video talking a little bit about negligent infliction of emotional distress. Repeats, Margaret O'Keefe is the mother of John O'Keefe. She learned of John O'Keefe's admission to the hospital immediately, came to see his body there. C.F. McCarthy's negligence caused the death. Okay, this is against C.F. McCarthy. There's going to be some repeats against multiple defendants. She suffered severe and profound emotional injuries manifesting in physical symptoms. So you're hearing some of the things that are important here when it comes to the elements of negligent infliction of emotional distress. First, and again, not an expert specifically on how Massachusetts handled this. Every state's very different, and we dug in on Florida with the impact zone and zone of danger. But for a lot of these intentional and negligent infliction of emotional distress, you either have to be there and view this happen, like see your loved one get hit by the car, or get hit by the car yourself, or hit by debris, or hit by the body flying through the air to have a cause of action. But in some states, reporting to the hospital and seeing the body with the injuries, that's enough to bring in this emotional distress claim. But What's also important, and I'm assuming Massachusetts has this, it has to manifest in physical symptoms. What does that mean? So you can't just say, yeah, I'm really stressed. It has to manifest. Do you have headaches? Does your neck get tight? Can you not sleep and you become an insomniac? You got to take pills. You got to treat with a psychologist or psychiatrist. It's making you a recluse. What physical symptoms are you having as a result of your emotional distress? It's not just enough to say you're stressed and not do anything or feel anything about it. And that's why they're saying it manifested in physical symptoms. And guess what? You notice what they don't say? What are those physical symptoms? You don't necessarily have to plead them. You got to prove them, but you don't have to plead them. Margaret's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and proximately caused by C.F. McCarthy's. And you can have, in case you haven't picked this up yet, multiple causes for the damages. So Reed, McCarthy's, and Waterfall, they're saying all together were the causes of these injuries and damages. A reasonable person in the same position as Margaret O'Keefe at the time of JJ's death would have suffered severe and profound emotional stress. This is another element. Can't just be her specifically, but a reasonable, objective person would also feel the way she felt under similar or the same circumstances. Wherefore, demands judgment against C.F. McCarthy's plus interest costs, any other relief or damages. If you notice, it's negligent infliction of emotional stress, and they're not asking for punitive damages because you can't get punitive damages for that. Okay, now John O'Keefe's dad, negligent infliction of emotional stress, same thing. He had to show up at the hospital, see the injuries, see the damage done. And his, again, manifested itself in physical symptoms. Paul O'Keefe, negligent infliction of emotional stress, C.F. McCarthy's. Okay. Margaret O'Keefe, now against Waterfall, negligent infliction of emotional stress, same thing. She had got there at the hospital. John O'Keefe against Waterfall now, different defendant. Paul O'Keefe against Waterfall. So we've handled negligent infliction of emotional stress from all three plaintiffs against the two bars. Okay, so we've gotten through those causes of action. I personally like this way of drafting complaints. Some people don't. Some people like couple it all up. Sometimes judges will make you split it apart. I think this is the easiest, cleanest way to understand it. And then if you settle one claim, you can just dismiss cause of action number 9 and keep going against all the others, and it's not confusing. So this is how I like it to be set up. So kudos for that. All right, now we get into count 10. In Florida, I don't think this would be appropriate, but negligent and or reckless infliction of emotional distress, which kind of sounds like intentional infliction of emotional distress. Usually you'd have to separate it out because there are different things for each of these. And again, when we talk about negligence versus intentional, there's another piece of insurance, right? And that's homeowners insurance. Sometimes homeowners insurance, and we read Amber Heard's, and I was kind of surprised at some of the stuff they covered, but depending on what the policy says and what they cover, if it's negligence, sometimes homeowners insurance will cover claims like negligent infliction of emotional distress, which could be an extra bucket of money that all these plaintiffs could collect from. Car insurance, homeowners insurance, maybe umbrella policies if she's got that, or her personally. But again, usually homeowners insurance will disclaim and deny any intentional claims. All right. So what's the difference, right? When we get from negligence from above, which are all just negligent, to this one that has and or reckless. Okay. Negligence caused the death. Severe and profound emotional injuries, all that's the same. Defendant Reed outrageously created a false narrative. So here's where we get to the other stuff, right? Not just the drinking and driving, but the other stuff they're claiming Karen Reed did. Margaret's emotional injuries, severe physical pain, emotional distress, and other harm were directly or approximately caused by defendant Reed's negligence. Again, they only put negligence here. They don't put I would have put recklessness here. I would have put recklessness here. I would have thrown recklessness in as well if I'm going to put it here, personally. Reasonable person would also have felt the same way. Okay? Same thing now with John O'Keefe. She outrageously created a false narrative. Paul O'Keefe, negligent and or reckless infliction. By the way, it also says here demands judgment against Karen Reed plus interest costs, any other relief. It does not say punitive damages. They asked for it before, so they're going to put it in here if they want it. Also, certain jurisdictions, you can't even plead punitive damages until you prove them. Then you have to ask for leave of the court, meaning permission from the court to go file another complaint with punitive damages in there. That's how Florida is. Seems like maybe that's not how Massachusetts is. If it is, the civil defense attorneys will probably file a motion to dismiss, and they'll have to refile the complaint without the punitive damages claim, but that just means they'll probably add it in later. Once they have facts to prove, and you have a hearing, and we've done this before in cases successfully where we go to hearing and we argue, this is one of those cases that rises to the level of gross negligence. We need to put in punitives. Judge says yes. We refile the complaint with punitives added, and usually more details to prove those punitives. Okay. Once again, outrageously created a false narrative. But to me, not asking for punitives here, not putting, gross negligence and stuff here, and not saying intentional here leads me to believe that this is pretty much just going to be taken as negligent infliction of emotional distress. Insurance companies love to deny coverage, so maybe they'll say it's intentional, or they don't cover it for X, Y, and Z reason. That wouldn't surprise me. But the way I look at it, it looks more like negligent. Now, here's a new plaintiff. We read about her in the beginning that she was going to be a party. We read a couple paragraphs about what happened to her, but she has not been a plaintiff in all of these other causes of action. Okay, why? Well, she didn't go to the hospital. She wasn't in that, zone of impact, danger, or viewing it, right? So that's why she's not on those other causes of action, and that's why she could get stuff as the part of the estate in the wrongful death claim, okay? But personally, specifically, what happened to her? Because John O'Keefe's parents also, in certain jurisdictions, could be considered part of that estate and collect from that. But things happened to them personally when they had to go to the hospital and see that and live through that and deal with the outrageous false narrative they're claiming that Karen Reed did. But how does Kaylee fit into this? Okay. They reallege everything up top. She's the niece of John O'Keefe, who's her guardian. She learned of John O'Keefe's death or injury when defendant Karen Reed woke her up at 4:30. So specifically what happened to Kaylee. Reed knew Kaylee was vulnerable, having already lost her parents at the age of 6. Yet, in Kaylee's presence, she spoke on speaker to various people between 4:30 and 5 on January 29th, and we're learning a little more about probably what Kaylee testified to. And again, why is Patrick not here? He didn't overhear these conversations. This is the act and the actions by Karen Reed that they're claiming caused emotional distress to Kaylee. And these same things weren't done in the presence of Patrick. At relevant times, Kaylee heard Reed say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. So that is a little vague and ambiguous as far as like admitting I did it or telling Kaylee I did it. But those are the quotes that they're going off of for this cause of action. It seems a little weak to me. As a result of the conversations defendant Reed had in her presence, Kaylee perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing event. So here's another thing that's really important. It's almost impossible to separate, but I'm going to tell you, and it's something we have to tell juries all the time. And you can tell me in the chat if you think you'd be able to do this, okay? We have to divorce in a situation like this, when Kaylee is claiming damages and emotional distress because of something Karen Reed did. We have to separate what happened to John O'Keefe. Even if you believe Karen Reed hit him with her car while drunk driving, that is not part of the emotional distress or damages that Kaylee suffered as a result of this IIED or NEID, negligent infliction of emotional stress, NIED. The only thing you can consider and the only damage or emotional distress is what was caused by Karen Reed's actions in front of Kaylee, saying that this happened to John O'Keefe. So we have to try to separate that. We can't say all the damage she suffered as a result of this happening to her uncle and guardian whom she loved. We have to keep that separate. Can juries do that? I don't know. I think that's tough. At or about 5 a.m., after waking Kaylee up and informing her that something had happened to JJ, Reed left Kaylee home alone. She intentionally and or recklessly inflicted severe emotional distress when she woke up Kaylee and informed her that she hit her uncle or that a snowplow hit her uncle. First off, telling somebody a snowplow hit something is, I mean, how else do you let a child know something happened to their parent? Now, maybe you didn't do it the right way, or maybe if you think you really were trying to hurt the child in the way that you were telling them, then maybe this cause of action can be true. Like, haha, look what happened to your uncle. Haha, you got what you deserved or whatever, something horrible like that, of course. But using verbiage like informed Kaylee to me is not verbiage I would have used. Defendant Reed either intended to inflict emotional distress or knew or should have known that emotional distress was likely to result from defendant Reed's conduct. And again, of course, emotional distress is going to follow when you tell a child that something horrible has happened to their parent, family member, uncle, guardian. Of course, but that's not what we're talking about. It has to be something other than delivering bad news. Then, after JJ was declared dead, Reed came home to the family house and feigned concern. Rather, it became clear defendant Reed was only there to collect her belongings. And this is kind of part of the Gabby Petito situation. You come home, you act like you didn't know, you're acting like you're so sorry, knowing full well you did this. The emotional distress suffered by Kaylee was severe, and no reasonable person could be expected to endure it. Karen Reed's conduct was extreme and outrageous. It aggravated emotional distress manifesting in physical symptoms. Kaylee suffered severe and profound emotional injuries as a result of perceiving JJ's death and or the injurious producing event, the consequence of Karen Reed's negligence. Karen Reed outrageously created a false narrative. Kaylee's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or proximately caused by Karen Reed's actions. A reasonable person in the same position as Kaylee at relevant times, including the time of JJ's death, would have suffered severe and profound emotional distress. And they want damages. They do not include punitive damages here. Pita, would J.O.'s dad saying he didn't find Karen guilty negate this entire suit? I don't know that he said that, so I'm not gonna like ratify that he said that. But if he said he doesn't think she did anything wrong, or doesn't think she drunk drove, or doesn't think that she hit John O'Keefe, then yes, that could be used to impeach him in the civil suit. Peter, could they sue the Alberts since it was on their property? I assume you mean the plaintiffs here. You have to still have a nexus. Just because something happens on your property doesn't mean you can get sued. Some lawyers think that, but there has to be something you did wrong. A liability hook. What did you do wrong to cause the damage, to cause the injury? Were you negligent, or did you intentionally do something wrong? Did you turn your eye? Should you have secured the premises and you didn't do that? So it's negligent security. Without that, you can't just sue somebody because it happened on their property as a plaintiff. Azam, in a civil case, does the verdict form have to have each and every one of these counts on it? Can they combine some counts, Peter? So civil cases, so a lot of times what's in the complaint doesn't end up being the same stuff on the verdict form. Sometimes you add causes of action, you amend the complaint. Sometimes you remove causes of action. So it's a long way off. And no, every single one of these doesn't have to be on there. They can do it differently. They can settle out with certain defendants. They can settle with both bars and just go to trial against Karen. So yeah. All right. It's been an hour. I got to bounce, but this was incredibly interesting to me. You guys know how interesting civil lawsuits are to me. So I appreciate you joining me and showing up to talk about this with me. If you want me to continue, if you want a part 2 on what our potential defenses are, how the Alberts and the McCabe's and everybody could potentially be involved, let me know. And we'll talk more about this civil lawsuit. Hit that like button, please, if you guys haven't already. It helps anybody else that's interested in the civil lawsuit to come here, hang out with us, ask their questions, get those answered. And make sure you subscribe if you haven't already. So much going on in this case. It's truly never ending. Thank you, Azam, for sending us off with a super sticker. Until next time, let me hit Deb's question. Peter, why was Jen McCabe allowed to be in the chat the first 3 days of the trial before she testified? I don't know that she was. I don't really want to get into that. She shouldn't have been, obviously, if she was sequestered. But that's all we got. If this video gets to, let's say, What do you want to do? 7,500 likes, we'll do a part 2. So hit that like button. 7,500 likes, we'll do a part 2. You guys are the best. Thank you so much. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.